In its judgment on Dr. Cassaglia's appeal following the Industrial Tribunal, the Supreme Court has found that for intimidating and abusive behaviour to constitute bullying, it must be persistent. It was not so in this case, and therefore a finding of bullying was not justified. The judgment also notes that while the appeal was on points of law alone, Dr. Cassaglia does not accept the chairman's findings of fact. The court also found that because Mr. Cassaglia's actions against an employee formed part of a single, isolated and unforeseeable incident, it should not have been attributed to the employer, in this case the GHA. The third ground of appeal, that Mr. Cassaglia had not received a fair hearing, was not allowed. The judgment said although some criticism can be levelled at the GHA for not making it clear to Mr. Cassaglia that they were adopting a neutral position and were not strictly representing his interests, he had sufficient notice of the claim to apply to participate in the proceedings. The appeal was therefore allowed on 2 out of 3 grounds. The GHA is to carry out its own investigation into the incident with a disciplinary board made up of 3 senior civil servants constituted 2 years ago after the GHA determined the charges of pushing and using inappropriate or offensive language were charges of serious misconduct. To date, the board has not heard a final hearing, with this having been adjourned on 6 separate occasions. In April 2019, a decision was taken by the board to adjourn the disciplinary proceedings until after the claim in the tribunal was determined. The outcome of this appeal was being awaited.